Hello dear students, I, Anuradha Goswami, Senior Assistant Professor, Department of Commerce from the Bhopal School of Social Sciences, welcome you all for this video presentation titled Contract of Guarantee. Under this video presentation, I will be covering the following points: meaning and definition of contract of guarantee, parties under contract of guarantee, essentials of contract of guarantee, and liability and rights of surety. I'll begin this session with the legal meaning of the term guarantee. Because of the word guarantee has different meaning being attached to it on the basis of different context. The legal meaning of guarantee is that it is a collateral promise to answer for the debt or obligation of another person who is primarily liable for it. A guarantee is a secondary obligation becoming operative only when the principal debtor is in default. Now let us understand the meaning of contract of guarantee. The contract of guarantee means a contract to perform the promise made or discharge the liabilities of the third person in case of his failure to discharge such liabilities. As far as definition of contract of guarantee is concerned, it has been defined by Black Law Dictionary as the assurance that a legal contract will be duly enforced. Section 126 of the Indian Contract Act defines a contract of guarantee as a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. A contract of guarantee is governed by the Indian Contract Act 1872. The object of a contract of guarantee is to enable a person to get a loan or goods on credit or an employment. The guarantor in such contracts assures the creditor that the person in need may be trusted, and in case of any default, he shall undertake the responsibility to pay. Thus, we can say any contract of guarantee is invisible security given to the creditor. A guarantee may be either oral or written. It may be express or implied from the conduct of parties. A contract of guarantee is a secondary contract that emerges from a primary contract between the creditor and the principal debtor. Here, we can infer from the above information that every contract of guarantee has three parties under it, namely principal debtor, creditor, and surety. Under contract of guarantee, the person who takes the loan is known as principal debtor. The person who gives the loan is known as creditor, and the person who promises to pay the debt if in the case the debtor is unable to pay is known as surety or guarantor. Let us take an example for further clarification. Suppose Bhavesh advances a loan of rupees 70,000 to Bharti. Dhruv, who is the boss of Bharti, promises that in case Bharti fails to repay the loan, then he will repay the same. In this contract of guarantee, Bhavesh is the creditor, Bharti is the principal debtor, and Dhruv is the surety. Now, I will explain yet another important topic, which is essential of contract of guarantee. The first essential feature is three parties and three contract. As we know that there are three parties under contract of guarantee, hence contract of guarantee involves three agreements. The first agreement is between the creditor and principal debtor, which gives rise to the debt guaranteed. The second agreement is between surety and the creditor, in which surety guarantees to pay the debt in case of default in payment by the principal debtor. The third and final agreement is between the surety and the principal debtor, in which the principal debtor agrees to indemnify the surety in case if he becomes defaulter. The second feature is concurrence of all the parties. Basically, concurrence of all the parties means that in a contract of guarantee, all the three parties under contract, that is the principal debtor, the creditor, and the surety, must agree to make such a contract with the agreement of each other. Here, it is important to note that the surety takes his responsibility to be liable for the debt of the principal debtor only on the request of the principal debtor. Hence, communication, either express or implied, by the principal debtor to the surety is necessary. The third essential feature is existence of primary liability. Under contract of guarantee, there must be an existing primary liability which is enforceable by law. As we know The main function of a contract of guarantee is to secure the payment of debt taken by the principal debtor. If no such debt exists, then there is nothing left for the surety to secure. In absence of primary liability, there cannot be any contract of guarantee. The only exception in this case is that a minor cannot be made primarily liable for debt. Therefore, in such a case, the surety himself is primarily liable. The fourth essential is consideration. There must be consideration between the creditor and the surety so as to make the contract enforceable. In a contract of guarantee, the consideration received by the principal debtor is taken to be the sufficient consideration for the surety. Thus, any benefit received by the debtor is adequate consideration to bind the surety. The consideration must be lawful. The consideration must be a fresh consideration given by the creditor and not a past consideration. It is not necessary that the guarantor must receive any consideration, and sometimes even tolerance on the part of creditor in case of default is also enough consideration. The fifth essential is that it must contain all the essential of a valid contract. Although a contract of guarantee is a type of contingent contract, yet all the essentials of a valid contract will apply on contract of guarantee as well. Thus, all the essentials requirement of a valid contract such as free consent, valid consideration, offer and acceptance, intention to create a legal relationship, etc. are required to be fulfilled. The sixth essential is the surety's liability is secondary. In a contract of guarantee, the liability of surety is secondary. This means that since the primary contract was between the creditor and the principal debtor, the liability to fulfill the terms of contract lies primarily with the principal debtor. It is only on the default of the principal debtor that the surety is liable to repay. The seventh essential is no misrepresentation. The guarantee should not be obtained by misrepresenting the facts to the surety. Though the contract of guarantee is not of ubermae fidei, that is of absolute good faith, and thus does not require complete disclosure of all the material facts by the principal debtor or creditor to the surety before he enters into a contract. But the facts that are likely to affect the extent of surety's responsibility must be truly represented. The eighth feature is no concealment of facts. The creditor should disclose to the surety the facts that are likely to affect the surety's liability. The guarantee obtained by the concealment of such facts is invalid. Hence, under such circumstances, the surety is free to avoid the contract. The ninth feature is that the contract of guarantee may be oral or in writing. A contract of guarantee can be either oral or in writing. It may be express or implied from the conduct of the parties. Moving ahead, let us now understand the types of guarantee, which are basically divided into two categories. 1. Specific or simple guarantee. 2. Continuing guarantee. The term specific guarantee means a single debt or any specific transaction. It comes to an end when such debt has been paid. And the term continuing guarantee means a guarantee which applies to a series of transactions. A continuing guarantee applies to all the transactions entered into by the principal debtor until it is revoked by the surety. A continuing guarantee can be revoked any time by surety for future transactions by giving a notice to the creditor. However, the liability of a surety is not reduced for transactions entered into before such revocation of guarantee. A continuing guarantee can be revoked in the following manner. Under the first condition, the surety can revoke his continuing guarantee by giving a notice to the creditor. Under second condition, if the surety die, then his guarantee is automatically revoked in respect of the future transactions unless contract to the contrary. Under third condition, a surety stand discharged due to the following conditions: novation, variance in terms of contract, release or discharge of principal debtor, loss of security, etc. Basically, these conditions covers all the points that I will be explaining under the heading discharge of surety from his liability. But first, let us go through the points related to the nature and extent of surety's liability. The first point says that liability of surety is coextensive. According to section 128 of the Indian Contract Act 1872, the liability of a surety is coextensive with that of principal debtors, unless there is contract to the contrary. It means surety is liable to pay only that amount which the principal debtor has to pay. This amount includes the loan money, interest, damages, cost of litigation, etc. Hence, the liability of surety can neither be more nor less than the principal debtor's liability. The second point says that surety's liability arises when principal debtor become defaulter. It means that the liability of surety arises immediately when the principal debtor defaults in making the payment. It is not necessary that the notice of default should be given to the surety. It means that the creditor is not bound to proceed first against the principal debtor before charging a case against surety. The third point says that surety can restrict his liability. It means that when a person becomes surety under the contract of guarantee, he is free to limit or restrict his liability up to a certain fixed amount which is expressly declared by him. The fourth point says that sometimes surety is liable though principal debtor is not liable. As we already know, the liability of surety is coextensive with that of the principal debtor, but in certain cases, due to operation of law, the principal debtors cannot be held liable, yet the surety remains liable. This is because the contract between the surety and the creditor is an independent contract, not a contract which is collateral. For example, when the principal debtor is minor, the surety is held primarily liable. The fifth point says that surety could have conditional liability. It simply means that in case surety puts some precondition to fulfill his liability, in such circumstances, surety will be liable only when the such precondition put by him is fulfilled first. For example, Shivam requires a loan from the bank. Shivam and Yashpreet both agree to guarantee the repayment of loan. Yashpreet has signed the necessary document, but Shivam did not. Here, Yashpreet is not liable for his guarantee because there was a precondition that repayment of loan is guaranteed by both Shivam and Yashpreet. The sixth point says that guarantee could be a continuing guarantee. Basically, in continuing guarantee, the liability of surety extends to a series of transactions over a period of time. The surety's liability in this case will continue till all the transactions are completed or till the guarantee is revoked by him for further future transactions. The seventh point says that no liability of sureties. It means that the surety cannot be held liable under the following two circumstances. First, when the creditor has obtained the guarantee by misrepresentation, and second, when the creditor was silent about the material facts of the contract. The eighth point says that no discharge of surety. It simply means that a discharge of principal debtor by operation of law does not discharge the surety from his liability. For example, if the principal debtor is being declared as insolvent, that does not mean that the liability of surety has also comes to an end. After understanding the extent and nature of the surety's liability, now let us go through these conditions under which he is being discharged from his liability. The surety stands discharged from his liability under the following three conditions. The first condition is by revocation of guarantee contract. The term revocation means cancellation. The liability of a surety can be discharged if the contract of guarantee is revoked in any of the following modes. A. Notice by surety. A specific guarantee cannot be revoked by surety if the liability has already accrued. On the other hand, a continuing guarantee may be revoked at any time by the surety in relation to the future transactions by giving notice to the creditor. B. Death of surety. According to section 131 of the Indian Contract Act, in the absence of any contract to the contrary, the continuing contracts of guarantee is revoked due to the death of surety. But the point to be kept in mind is that the revocation by death of surety is effective only for future transactions because his legal successor remain liable for those transactions which has already had been made before the death of the surety. C. Novation. The term novation means that a new contract is made in place of the old one. In such case, the original contract comes to an end and therefore the surety stand discharged in relation to the old contract. The second condition is by conduct of the creditor. The surety may be discharged from his liability because of some specific conduct of the creditors in any of the following circumstances. A. Change in terms of contract. According to section 133 of the Indian Contract Act, any variance, that is change in terms of contract of guarantee, if made by the creditor or the principal debtor without the consent of the surety, discharges the surety from liability in relation to the transactions subsequent to the variances. Release or discharge of the principal debtor. Section 134 of the Indian Contract Act lays down two conditions under which the surety is discharged from his liability. The first condition is when the creditor makes a fresh contract with the principal debtor by which the principal debtor is released from his liability, and the second condition is if the creditor does any act or omission which has a legal effect of discharging the principal debtor from his liability. C. Arrangements made without the consent of surety. According to section 135 of the Indian Contract Act, if the creditor enters into a contract with the principal debtor without the consent of surety and makes following agreement: A. Settlement of debt by mutual concession. B. Promise to give time to the principal debtor. C. Promise not to sue the principal debtor in all such condition, the surety stands discharged from his liability due to such arrangements. D. The creditor act inconsistent with the rights of surety. According to section 139 of the Indian Contract Act, if the creditor does any act or omits to do any required act and both these conditions damage the remedy available with the surety against the principal, then the surety stands discharged from his liability. E. Loss of security. According to section 141 of the Indian Contract Act, if the creditor loses or without the consent of the surety parts with the security given to him by the principal debtor at the time of making the contract, the surety is discharged to the extent of the value of the security. The third condition is by invalidation of contract of guarantee. A contract of guarantee can be avoided if it becomes void or voidable at the option of the surety. A surety may be discharged from his liability under the following conditions. A. Guarantee obtained by misrepresentation. As per the Indian Contract Act section 142, when a misrepresentation is made by the creditor relating to a material fact in the contract of guarantee, the contract becomes invalid and surety's liability stands discharged. B. Guarantee obtained by concealment. As per the Indian Contract Act section 143, when a guarantee is obtained by the creditor by means of keeping silence regarding some material facts relating to the contract of guarantee, the contract of guarantee becomes invalid and sureties stand discharged. C. Failure of co-surety to join as a surety. As per the Indian Contract section 144, when a contract of guarantee provides that a creditor shall not act on it until another person join in it as a co-surety, the guarantee is not valid if that person does not join. Now, dear students, let us discuss the rights of surety. After making the payment and discharging the liability of a principal debtor, the surety enjoys various rights. These rights can be studied under three heads as: number 1, the first right is right against the principal debtor. The right of surety against the principal debtor are as follows. A. Right of subrogation. Section 140 of the Indian Contract Act 1872 lays down that when the principal debtor becomes defaulter and the surety had paid the debt, then surety will enjoy every right of the creditor which he had against the principal debtor. It means that now surety steps into the shoe of creditor and he can claim the amount of debt from the principal debtor. B. Right of indemnity. Section 145 of the Indian Contract Act 1872 lays down that in every contract of guarantee there is an implied promise by the principal debtor to indemnify, that is, to pay back the surety whatever amount he has rightfully paid under the contract of guarantee. 2. The second right is right against the creditor. The surety has the following rights against the creditor. A. Right to securities. According to section 141 of the Indian Contract Act, a surety, after paying the liability of the principal debtor, is entitled to the benefit of every security which the creditor has against the principal debtor at the time of making of contract. It is immaterial whether the surety is aware about the existence of such security or not. B. Right to claim set off. The term set off means counter claims or deduction from the amount of loan. When the creditor sues the surety for payment of principal debtor's liability, the surety is entitled to claim set off, if any, which the principal debtor has against the creditor. The third right is against the co-sureties. In a contract of guarantee, if debt is guaranteed by two or more persons, they are known as co-surety. According to section 138 of the Indian Contract Act, when there are several co-sureties and one of them has been compelled to pay the entire amount of debt of the principal debtor, such a co-surety will be entitled to the following rights against the other co-sureties. A. Equal distribution. As per the section 146 of the Indian Contract Act, where there are two or more sureties for the same debt or duty with or without the knowledge of each other, the co-sureties are liable to contribute equally to the extent of default made by the principal debtor in the absence of any contract to the contrary. B. Liabilities of co-sureties in case of different sum. As per the section 147 of the Indian Contract Act, where the co-sureties have agreed to guarantee different sum, they are liable to contribute equally but subject to the maximum of the amount guaranteed by each of them. C. Right to share the benefit of securities. When at the time of guarantee, one of the co-surety receives a security from the principal debtor, or on payment of debt he receives security from the creditor, other co-sureties are entitled to share equally the benefit of such security. Thank you, dear students. I hope this video presentation will help you in understanding all the basic concepts related to the contract of guarantee.